like short. I would keep mine very short as well.
Yeah. Good evening, everyone. I'm delighted to welcome you all to tonight's session. I'm Prajwal Ghale, the coordinator of KU Vista Alumni Network, and it's a pleasure to have so many of you join us here, especially those who have registered, and especially those who attended the previous session with Mr. Bone on fundamentals of international arbitration. Today, we're delving deeper into the topic of enforcement and challenges to arbitral awards, and we're privileged to have two esteemed experts leading the discussion, Mr. Gary Bourne and Mrs. Ara Dixit. Ms. Dixit will be moderating the session and bringing her valuable insights to the table. Mr. Bourne, on the other hand, is a true luminary in the field of international arbitration, and his reputation precedes him. It's no exaggeration that the success of our first session, as well as tonight's, owes much to his expertise and guidance. We're fortunate to have him here once again with us, sharing his wealth of knowledge and expertise. Joining Mr. Bourne is Mrs. Arya Dixit, an accomplished international arbitration lawyer who honed her skills under the mentorship of Mr. Bourne in WilmerHale. She currently serves at Gifford Chance, Germany, bringing a very unique perspective to our discussions tonight. Without further ado, I pass the baton to Mrs. Dixit to kick off what promises to be a very enlightening and engaging session. Yeah, thank you.
Thanks, Prajwal. Thanks for the very, very kind introduction. Yeah, for those of you who don't know me, I'm Arya. Nice to meet you all. I'm joining you again from London today. It seems like I join you from London all the time, but it made sense because I have a filing this week and it made sense to be with the rest of the team here in London. I hope Nepal has a better weather than London, which is kind of cloudy. It's kind of, it's not so warm yet, but I hope you guys are all enjoying the sun in Nepal. And I will try to keep my session very, very short because I know most of you are here for Gary rather than me. So I will just try to discuss the Nepalese perspective and talk about how awards are recognized and enforced in Nepal. And I will talk about very recent two Supreme Court judgments that were rendered and where the Supreme Court denied recognition and enforcement of the award. So I don't have slides like Gary because I have printed mine. But I have heard that Gary has prepared a huge slide, and that's very typical of Gary to be over-prepared. But okay, just to start with, the New York Convention, as the name suggests, it's recognition and enforcement of foreign arbitral awards. So to start with, I would like to, if there's anyone in the audience who would like to participate, but there's a difference between recognition and enforcement. And Prajwal, do you want to guess what's the difference between recognition and enforcement?
On the plain meaning, recognition means I see you, but on enforcement, it means I'm going to enforce what I see though. So
yeah, that's not far from what I was going to say. So I think recognition has more of a defensive purpose, whereas enforcement is more of a sword and a shield. So the defensive purpose of recognition is to prevent the possible filing of a lawsuit dealing with the same issues as the award sought to be recognized. And enforcement is so that the successful party aims to ensure that the award is complied with and they get the redress which they're entitled to, right? So that's one thing that we need to understand. And then the next step, once an award is rendered, is what happens when an arbitral award is rendered, right? So you then would go to the national court. In case of Nepal, we know that Prajwal and Imisha very kindly put together this research for me. So then you would go to the High Court to recognize the award, the competent court would, that's like, let's talk about the procedural aspect. The competent court would be the High Court of Nepal, and the formalities would just really be the original and certified copy of the award, and original and certified copy of the arbitration agreement. And if the award is rendered in a foreign language, then a Nepalese translation of that award. As all of you may know, Nepal still follows Nepalese as our official language, and we're also required to do all court proceedings in Nepalese, including our bar exams. So yeah, and the prerequisites of like how an award would be rendered, I mean, how an award would be recognized or enforced is very the the prerequisites are kind of very similar to the New York Convention, Article 5, where all the Article 5.1 and Article 5.2, where all the requisites, there is courts usually recognize awards unless they have certain criteria that are mentioned in Article 5 that could possibly deny recognition and enforcement. And then the other question is, again, like, what's a foreign arbitral award? Maybe Abba can try. What's a foreign arbitral award?
Foreign arbitral award is something that is not given within the national territory of the parties.
Yeah, okay. So foreign or arbitral award is something that, so you seek recognition and enforcement of the award in Nepal, and if that award has been rendered in Nepal, then that doesn't amount to a foreign arbitral award, right? So it should occur in a different seat, which carries with it certain like jurisdictional considerations. So that's, if you look at Article 1.1 of the New York Convention, that's where a foreign arbitral award is defined. It's a pretty long provision, but let me just read it out, like the relevant provision for your benefit. It says, the convention shall apply to the recognition and enforcement of arbitral awards made in the territory of a state other than the state where the recognition and enforcement of such awards are sought, right? So everything, I mean, if you have like an issue with anything, just always go back to the New York Convention. You will always find the answers there. So what's the legal basis for recognition and enforcement of foreign arbitral awards? So the legal basis is like twofold. One is international law, which we derive from the New York Convention, the UNCITRAL Model Law, Article 36. And the other one is the Nepalese Arbitration Act. So whenever you're seeking to recognize and enforce an award, you would look at whether Nepal is a party to the New York Convention, whether the Arbitration Act provides for certain like formalities. Like initially I spoke about what is the formal procedure to recognize an award, right? So those come from the Nepalese Arbitration Act. So those are your legal basis for recognition and enforcement of foreign arbitration awards. And then moving on, so Nepal, in the beginning, I remember we spoke about there's a difference between recognition and enforcement, but I mean, the Nepalese law directly allows for enforceability of the award. There's no need to go through a process of recognition and enforcement. Even if the award has no enforceable content, you would still you would still apply to the High Court for the enforcement of the award, right? And so what the Nepalese court scrutinize when they look at an award? Like, what would they scrutinize? I mean, you guys are the hosts, so you guys can speak. I know the people in the audience can't really speak, so.
First of all, they check whether there has been an actual arbitration and there was an actual arbitration agreement or not, and whether the arbitration award that was given was final and binding or not.
That's right. And when I ask you about what would the Nepalese court scrutinize, I basically want to take you to Article 5 of the New York Convention, and to like, if you look at like Article 5 of the New York Convention, it's actually like two two-pronged, like there's Article 5.1 and then there's Article 5.2. Article 5.1 is usually invoked by the opposing party. So usually it's the invalid arbitration agreement under Article 5.1a, which talks about lack of subjective arbitrability or formal and material invalidity of the arbitration agreement. The second one is violation of the right to be heard. I'm sure like Gary will cover these in much more detail, but just like before I discuss my two judgments, I wanted to give you some context as to what I'm saying. The third is excessive authority under Article 5.1c. 4 is irregularities in the constitution of the tribunal or the proceedings. This is the Supreme Court judgment I'm going to discuss about today. And 5 is lack of a final and binding award, right? And then there is Article 5.2, which is an ex officio ground for challenging an award, which is lack of objective arbitrability. If like the subject matter per se is not arbitrable in the country, in the enforcing country, or there is a violation of public policy. So those are Article 5.2, right? So now moving on very quickly to the two judgments that I'm going to discuss. One, I think we kind of briefly discussed last week. Oh no, not last week. It was like kind of briefly discussed like a month ago when we had this session with Gary about the Nepalese Supreme Court not recognizing an award that has been rendered by an Indian arbitral tribunal, right? And that case is Sanghi Brothers. I will send you the case name after the class. But what happened was there was an Indian arbitral tribunal which rendered an award, and when they came to the Nepalese courts, when they came to the Nepalese High Court, the High Court denied recognition and enforcement, saying that the Indian Arbitration Act has provisions of reciprocity, and therefore they do not recognize. They would not have recognized or enforced awards rendered in Nepal, right? And that's how the Nepalese Supreme Court then, the award creditor filed a writ of mandamus in the Nepalese Supreme Court. And again, the Supreme Court rendered a very similar judgment whereby they were like, look, according to Article 45 of the Indian Arbitration Act, there is a reciprocity provision whereby the Indian Arbitration Act only mentions 48 countries where they have notified in their official gazette, like only 48 countries from which they would recognize and enforce arbitral awards from, and Nepal is not in one of those lists, and therefore they would not recognize and enforce arbitral awards in that kind of scenario. So the second case is a case that happened in Korea. I mean, I was shocked to see how little like the amount in dispute is. It's like just a little under 2 million. It also, I mean, it's something, but it's also like, like it was cute. Anyway, so the other award was like rendered by the Korean Commercial Arbitration Board. The facts of the case were such that there was a Nepalese party and a Korean party which dealt with construction of roads within one of the hydropower projects in Nepal, and there was a default in the Nepalese party defaulted in the construction, and the Korean party then claimed 1,900,000 in damages. So what's interesting is like clause 7 of this arbitration, clause 7 of the arbitration provision, which simply provided that the parties will go to arbitration. So this was sort of like a multi-tiered dispute resolution clause, which said that parties shall settle the dispute amicably, and then failing such amicable dispute settlement, the parties shall go to arbitration. And there was clause 10 of the contract, which says the governing law of the contract shall be Korean law, right? And there was no So the arbitration agreement had no, like, they did not like sort of specify the procedure of what the arbitration procedure would be, or how would you appoint arbitrators, or what would be the center of arbitration, or what would be the governing law of the arbitration agreement. So the Korean party then unilaterally goes to the Korean Arbitration Commercial Board, and then the Korean Arbitration Commercial Board then unilaterally um, uh, appoints a 3-member tribunal. The arbitration goes forward, and then they render an award and grant damages in the sum of 1,900,000. Anyway, so the award creditor then comes to Nepal and tries to enforce the award, and the High Court is like, oh no, like, there's been a violation of Article 51D, in the sense that the arbitral authority, the composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties, right? And so they again, the award creditors then again go to the Supreme Court, filing a writ of mandamus. And the Supreme Court then gives like a very, very interesting judgment. I mean, I agree with some parts of the judgment and I don't agree with some. So what the Supreme Court then says is like, in the event that there is no law governing, so the Supreme Court then starts with like this whole separability principle, and says that in the event that there is no law governing the arbitration agreement, it's not necessary that the law governing the underlying contract also govern the arbitration agreement. So in that event, the Korean Arbitration Act would not have applied, right? And well, the Supreme Court then does not actually do like a conflict of laws analysis to then say, okay, like the law applicable to the arbitration agreement would have been Nepalese law, I mean, would have been Korean law, would have been English law, whatever, but it just simply says, oh, well, like it's not necessary that the Korean Arbitration Act would have applied. Then it then subsequently goes on to say that, oh, well, but even if the Korean Arbitration Act would have applied, the Korean Arbitration Article 12 of the Korean Arbitration Act does not then mention or state that the Korean Arbitration Commercial Board should have been the institution who would administer this this arbitration, and therefore the Nepalese party was not given a proper procedure, or like the composition of the arbitral tribunal was not in accordance with the agreement of the parties. And then there was another issue about the multi-tier dispute resolution clause, where the Supreme Court then says that, oh, well, in any event, like this was a multi-tier dispute resolution clause, and in the event that there is a multi-tier dispute resolution clause, you should have gone for an amicable settlement, which from the records we cannot see that you actually went for an amicable settlement. And well, while it's true that this was a multi-tier dispute resolution clause, like unless the dispute resolution clause was a condition precedent to the contract, it's usually just a matter of admissibility versus jurisdiction, right? So the arbitral tribunals just still assume jurisdiction in these sort of cases. So the Nepalese Supreme Court then finally said that, well, this was against our public policy, because the Nepalese party was not given like a right of fair hearing in the event that the arbitral tribunal was like just appointed one-sided, like on the application of the claimants, and therefore you have violated the Nepalese party's rights of natural justice, and therefore the award was rendered unenforceable. So that's the Nepalese context. I hope I was I hope I summarized it fairly quickly, and hopefully everybody understood. But I'd like to know from Gary, as he discusses his part of the lecture, as to what did you think about this de novo judicial review of the tribunal's procedural decision. Maybe you could discuss the China National Award, or the Sanum Sanum Award that was like rendered in Singapore. Um, and I think the other thing, I think maybe Gary will disagree with me. The other thing about the New York Convention that actually, like, I mean, it's not the New York Convention that bothers me, but it's actually Gary's book that actually really, really bothers me. His opinion about Article 5.1e, which says that, well, anything, awards that have been set aside in the seat of arbitration should not be recognized or enforced, right? And there are like countries like Germany, which kind of strictly follow this, that if the award has been set aside by, let's say, an award like has been rendered in India and it has been set aside by Indian courts, like it cannot be enforced in Germany or whatever. But like, I think there's an opinion in Gary's book which says that, oh, even if it has been set aside, it should still like be enforced. I know Gary is like a huge fan of enforcing and like giving deference to arbitral tribunals. So I mean, I would also, I mean, yeah, like, you know, there is also like the classic, like a lot of like those French cases like Cromalloy and all of these, where they are like, well, an arbitral award is not tied to any national jurisdiction. It's like a bigger part of this international, you know, transnational law. And so, you know, so there is like the French extreme, and there is also like countries like Germany, which kind of believe in like comity and kind of making sure that they respect the jurisdiction of other nations. And if it has been set aside, they're like, okay, like that's one reason to not enforce the award. So I would be very, very interested in hearing about Gary's opinion. And I mean, if anybody has questions, just feel free to like raise your hand and ask now, or if you have questions, just sort of ask maybe in the last like 40 minutes. Gary, what we've decided to do for today is that we've tried to like keep the session fairly short. So maybe you have another like 50 minutes to an hour to talk about recognition and enforcement, because a lot of like kids were really interested in, like, you know, they have like a bunch of questions about your book, about how you started and everything. So we have prepared a bunch of questions. So yeah, so maybe you have like 50 minutes to an hour to discuss your part. And then if anybody has questions, I think there's somebody in the chat. Okay, no. So if anybody has questions, just feel free, or just ask questions in the end. I'm happy to do whatever.
That sounds great, and it also sounds like an invitation for me to get started. Arya, of course, is always a hard act to follow, and I hope you'll be patient with me in trying to elaborate on what she said, because she's done a really good job in addressing most of the issues that I was asked to address. Just very quickly, and maybe if we look at the slide, the things I over ambitiously, if we go to the next slide, I over ambitiously would like to cover would be general principles, very quickly, some jurisdictional requirements then, and Arya touched on it briefly, proof of international arbitral awards, as well as their presumptive validity, and the grounds for denying recognition and enforcement of international or foreign arbitral awards. We probably won't be able to get to the remaining topics that you can see on the slide, although I may touch on them in passing. Let's just moving to the next slide, start with general principles. Where we are in the arbitral process at this stage, when we have an award, is pretty much at the very end of that process, the arbitral process. You've had parties who presumptively have entered into an arbitration agreement and have, again, presumptively constituted an arbitral tribunal, which has conducted an entire arbitration. And at the end of the arbitration, the arbitral tribunal, not, of course, the arbitral institution, but the arbitral tribunal has made this thing called an arbitral award. That award, in almost all cases, is intended to be final and binding. You know that it's intended to be final and binding because In many circumstances, the parties' arbitration agreement may say that expressly in its text. There'll be a provision in the arbitration agreement itself, which says that the award of the tribunal shall be final and binding or final or something to that effect. Even if there's not a provision like that specifically in the arbitration agreement, there may very well be a provision like that in any institutional rules that might be applicable. There's certainly a provision to that effect saying that the tribunal's awards will be final and binding in, for example, the Singapore International Arbitration Center's arbitration rules, the ICC's rules, the LCIA's rules, and other leading arbitral institutions. And even if it's an ad hoc arbitration without either of the provision in the rules or a provision in the arbitration agreement, almost all national laws treat arbitral awards as presumptively final and binding. The parties go to arbitration to finally resolve their dispute. And the award is meant to be the end of proceedings, and it's meant to be complied with. In practice, and we can see this on the slide, most international arbitral awards are voluntarily complied with. There's a variety of different efforts at empirical evidence. Some of them suggest somewhat less than 90%. But my experience, I think the experience of lots of practitioners is in international arbitration is that most awards are complied with voluntarily. Despite that, in some cases, and the two Nepalese cases that Arya points out are good examples, the losing party, the so-called award debtor, may feel that the award is wrong or may just not be interested in paying money to the award creditor, the party in whose favor the award is, and therefore will refuse to comply with the award, either to pay the money the award directs it to pay or to do whatever else is directed in the award. For example, to stop using a patent or stop marketing certain products. And in those circumstances, where the tribunal has ordered something in its final and binding award, and the party has refused to do the thing that it's ordered, then the questions of recognition and enforcement and relatedly annulment and setting aside arise. In that case, the award creditor, the party in favor of whom the award is made, needs to either seek to recognize and enforce the award or confirm and enforce the award in the arbitral seat. So if the award is made in say, Frankfurt, Germany, where Arya usually is, one would go to a German court, have the award confirmed as a judgment of a German court, and then enforced against the assets of the award debtor, if they're in Germany, in the same manner as a German judgment of a court would ordinarily be enforced. And that is definitely one option that can be pursued in some cases, indeed many cases in both domestic but also international arbitration. The unique thing perhaps about the New York Convention and international arbitration, though, is that one's options as an award creditor are not limited to the arbitral seat. Instead, one can go to any one of the other 175, one or so contracting parties to the New York Convention and seek to have the award recognized and enforced. And by recognition in that context, what is meant is that a foreign court recognizes the award, and in doing that, perhaps the easiest way to describe it is accepts it into that country's legal system. And so if the German award is taken, for example, to Nepal for recognition, a Nepalese court would recognize the award, making it effective in Nepal, typically as a Nepalese judgment, if recognition is granted, which then permits it, as Arya says, both to be used defensively to cut off the possibility of future litigation against the award creditor, but also offensively by the award creditor, who would then seek to enforce the judgment coercively against the assets of the award debtor in the same way that a judgment might be enforced. Seize a bank account, put a lien on property, and and things of that nature. In the New York Conventions, one of the fundamental purposes of the New York Convention, of course, is to make awards more readily enforceable across national borders. Let's look at the next slide quickly. And as I just mentioned, the New York Convention establishes what the slide correctly describes as a robust pro-enforcement regime by which awards are easy to prove on the one hand, presumptively valid and enforceable on the second hand, and then with multiple hands here, subject to only very limited exceptions for non-recognition. The New York Convention in many countries is implemented fairly faithfully by national arbitration legislation, and in many cases, something like the UNCITRAL model law on international commercial arbitration, which basically tracks the language of the New York Convention in the relevant articles. There are jurisdictional requirements that limit the circumstances in which both the convention and national arbitration legislation applies, and we'll look briefly at those. Let's move to the next slide, please. And again, this picks up on points that I've just made. The convention in Articles 3 and 4, and we'll look at those in just a moment, establishes a rule of presumptive validity of foreign and also non-domestic arbitral awards, and then establishes only very limited exceptions to that presumptive validity of awards. And we'll look at those exceptions, as Arya has said, are listed. There's 7 of them in total, but they're listed in Articles 5.1 and 5.2. There are 5 exceptions in Article 5.1 and 2 additional ones in Article 5.2. Importantly, there is no review of the merits or the substance of the arbitrator's decision in a recognition proceeding. There's no exception in Article 5 for a badly mistaken judgment on the part of the arbitral tribunal. Next slide, please. What you do have in the convention, and you can see this on the slide, are essentially 7 grounds. I've broken them out a little differently here for non-recognition of awards under the convention. Article 5.1a permits non-recognition on the basis that there is no valid arbitration agreement. And we'll try and discuss that in a little more detail. Article 5.1b permits non-recognition where a party was denied an opportunity either to be heard or to present its case. In some national legal systems, it's referred to as a denial of procedural regularity or a denial of due process rights. Article 5.1c permits non-recognition of an award where the arbitral tribunal has exceeded its jurisdiction. This is related rather closely to Article 5.1a, which is where, as we mentioned, the arbitral tribunal lacks any jurisdiction at all. There's simply no valid agreement to arbitrate. In Article 5.1c, there is a valid agreement to arbitrate, but the arbitral tribunal exceeds the jurisdiction that arbitration agreement gives to it. For example, the parties have agreed to arbitrate disputes concerning subject matter A, and the arbitral tribunal decides disputes that instead concern subject matter B, a different topic, perhaps a different contract or a different time period than that covered by the parties' arbitration agreement. Article 5.1d, which Arya briefly mentioned, permits non-recognition where there is a valid arbitration agreement and the arbitral tribunal doesn't exceed its jurisdiction, but instead it doesn't, or the arbitral institution that administers the dispute doesn't comply with the procedural requirements of the parties' arbitration agreement. And for example, the parties might agree to arbitrate in Nepalese, but instead the arbitral tribunal says, well, we think it'd be easier actually to arbitrate in Hindi or in English, and therefore conducts the arbitration in that language. That would be non-compliance with the procedures set forth in the parties' arbitration agreement, and would potentially be a ground for non-recognition of the award. The next two bullet points, lack of binding status of the award and annulment of the award in the arbitral seat, are Article 5.1e, which Arya mentioned. And I will come back to those in a few minutes. The basic concept of both of them, though, is that you need not necessarily recognize an award if in the arbitral seat that award isn't regarded as final and binding, or alternatively, if, again, in the arbitral seat, the award has been set aside or annulled for some reason. These both warrant more discussion, the Article 5.1e grounds, and we can talk about them in due course. Not exactly falling into any one of the previous 5 provisions, Articles 5.1a, b, c, d, and e, is the bias of the arbitral tribunal, or put differently, the lack of independence and impartiality. It's widely recognized that a tribunal's lack of independence, or alternatively impartiality, would be grounds for setting aside an arbitral award and also denying recognition of an arbitral award in our context, the context of recognition and enforcement. But none of the first 5 or the next 2 grounds for non-recognition in the convention actually address this point specifically. Nonetheless, national courts will deny recognition of awards where it can be shown that the arbitral tribunal was biased or alternatively lacked independence and impartiality. The basis for that is sometimes public policy. You can see that as the next example, and it's in Article 5.2, not Article 5.1. Sometimes bias is included within denial of an opportunity to be heard, on the theory that if the arbitral tribunal is biased against you, then although they might pretend to hear you, they're not actually listening. Or in some cases, non-compliance with the parties' agreed arbitral procedures, on the theory that the parties agreed to arbitrate before an independent and impartial arbitral tribunal, which in fact didn't happen because the tribunal was biased. In any event, under one of the various general grounds for non-recognition that I mentioned, national courts will, if bias or lack of independence and impartiality can be demonstrated, very often deny recognition. The final 2 grounds for non-recognition under the convention, violation of public policy and non-arbitrability, are contained in Articles 5.2, 5.2a and 5.2b. In each case, somewhat unusually as compared to the 5.1 grounds, one that needs to look to local law, national law, in the jurisdiction where recognition and enforcement is being sought. So to go back to our German Nepal example, if an award is made in Germany and is brought to Nepal for recognition, Article 5.2 permits Nepalese court to deny recognition if recognizing the award would violate the public policy of Nepal. And if instead the German award was taken to, say, Taiwan, then if Taiwan were a party to the New York Convention, which it's not because China won't let it be, unfortunately, then you would look to Taiwanese public policy as defined in the Republic of China's national laws to decide whether or not Article 5.2 permitted non-recognition. And it's a sort of escape valve in a sense, unusually for an international treaty. One looks to local law, national law in the jurisdiction in question, the place where recognition is being sought, to determine whether or not recognition should be denied under local law. And the same is true with respect to non-arbitrability. An award can be denied recognition if the dispute in question, the dispute addressed by the arbitral tribunal, wasn't capable of settlement by arbitration, or in the words of most authorities, non-arbitrable. And in looking at whether a dispute is non-arbitrable, you look to the law of the recognition forum. Again, in my German Nepal example, a German award brought to Nepal, one would look to Nepalese rules regarding arbitrability, non-arbitrability. As Arya mentioned, the violation of public policy and non-arbitrability exceptions are ex officio. That means the court where recognition is sought can raise these grounds of its own motion. They need not be invoked by the award debtor, but the court can independently deny recognition based on these grounds, even if they have not been invoked by the award debtor. That is in contrast to the first 5 grounds under Article 5.1 that we just looked at, lack of valid arbitration agreement and so forth. All of those grounds must be raised specifically by the award debtor. The recognition court cannot, under the convention, properly raise these grounds sua sponte of its own motion. Let's move to the next slide, please. Still on general principles. And while we're waiting for the next slide to come up, recall that all of these 7 grounds in Article 5.1 and 5.2 are, if I can put it this way, optional. The New York Convention never requires non-recognition of awards. The New York Convention only requires recognition of awards, and we'll see that's what Articles 3 and 4 of the New York Convention do. Requires countries to recognize foreign awards in certain circumstances, and then establishes exceptions to that obligation, although presumptively national courts in New York ratifying states, New York Convention ratifying states, must recognize foreign awards. They are relieved of that obligation in some circumstances, i.e., where Articles 5.1 and 5.2 exceptions would apply, but they are never obligated under the convention to deny recognition. The convention only establishes a floor, if we can put it that way, for recognition. National courts must recognize foreign awards in certain circumstances. It never imposes an obligation to deny recognition, never, to use my analogy, never imposes a ceiling on the recognition of foreign awards. And we'll come back to that when we talk about Article 5.1e. Just very quickly, and again, by way of general principles, which are helpful to situate us. What are the possible forums where, when the award debtor refuses to comply voluntarily with the award, what are the available forums for recognition of an award? And we've already answered that question in a sense. One available forum is the arbitral seat itself, the place where the arbitration occurs, the place where the arbitral award is made. But critically, under the New York Convention, that award, made, say, in Germany, can be taken firstly to Nepal, where, hypothetical, the award debtor is based, but also to 170 other countries in addition to Nepal and Germany, because there are 172 contracting parties, states that have ratified the New York Convention. And in all of those countries, the award is subject to recognition under the convention's international standards, with only very limited exceptions. In addition, one could also go to non-convention states, contracting parties. I mentioned that Taiwan, along with a few other countries, North Korea, for example, is not a party to the New York Convention, and at least theoretically, therefore, the award also could be taken there, but importantly, without the protections of the New York Convention. We won't spend much time on this, but there are also, in some cases, arguments that a party has waived its rights to resist recognition of an award. And those types of agreements raise questions both as to what they mean, but also are they enforceable or not. And finally, just very briefly, there are some circumstances that are addressed in Article 6 of the New York Convention in which recognition and enforcement proceedings under the convention can be suspended, often based on the pendency, the fact that there are pending in the arbitral seat proceedings to annul or set aside the arbitral award. So with that background, just very quickly, if we can move to the next topic, jurisdictional requirements. And what I'm going to do is just summarize what we have on the slide, because to some extent, I think we touched on this in our previous class, and also because we have limited time. The New York Convention, as I mentioned and as Arya discussed, establishes a pro-enforcement regime that makes it easy to enforce these things called arbitral awards, subject to only quite limited exceptions. What is the scope of that pro-enforcement regime? It is limited to proceedings that satisfy the 6 requirements that you can see on the current slide. And as I mentioned, I'm only going to very briefly summarize those. Most obviously, the New York Convention only applies to things called arbitral awards. It doesn't apply to national court judgments. It doesn't apply to recommendations by mediators. It doesn't apply to things like expert determinations, which may look very much like arbitral awards. It only applies to an award, i.e. a final decision made by an arbitrator or arbitral tribunal. And it needs to resolve a dispute that arises out of differences between the parties. There has to be a disagreement. Although consent awards, i.e. awards that both parties agree to, are subject to recognition under the New York Convention. It has to concern a commercial relationship in many cases. There's an exception that permits contracting parties to the New York Convention to limit recognition only to awards arising out of commercial relationships, and roughly half of all the contracting parties have made that reservation. The definition of commercial is quite broad in practice, and it doesn't usually pose difficulties. The arbitration and the award have to arise out of what's called a defined legal relationship. Again, this is mostly a theoretical issue in the sense that almost all commercial arbitrations, indeed investment arbitrations, arise from some sort of contractual or similar relationship, and which is quite clearly a defined legal relationship. There needs to be some sort of underlying relationship between the parties that gives substance to the agreement to arbitrate. Some commentators have suggested that if 2 parties who had no relations whatsoever with each other just agreed to arbitrate all of their future disputes, that might not be an arbitration agreement arising from a defined legal relationship. But as a practical matter, this virtually never poses an issue. The 2 most important jurisdictional requirements are the last 2 on the current list. The New York Convention only applies to foreign and non-domestic arbitral awards. Arya mentioned this, but the basic concept, and again, I'll go back to the German Nepal example, is that the convention makes it easy to enforce a foreign award as opposed to a domestic award. The award made in Germany, and by that I mean the award being made in the arbitral seat, would, in this case, be made in Germany, and therefore would be domestic in Germany and not covered by the New York Convention, but it would be foreign in Nepal and thus covered by the convention. The same award can be foreign in one place and domestic, of course, in another place. The German award would be domestic in Germany and foreign both in Nepal, but also anywhere else other than Germany that you took the award to, including, say, France or the UK or the United States or India. There's a very limited category of so-called non-domestic awards, which are, in practice, they're not particularly important, but there are some countries which will treat awards that are made domestically, i.e. an award made in the United States, as nonetheless non-domestic because of its international connections. And the importance of doing that is that it makes the New York Convention available for recognition and enforcement of that award in the same country. And therefore, an award made in the United States, and this is recognized by Article 1, the possibility of a non-domestic award, an award made in the United States can, if treated by the United States as non-domestic, as international awards are, can be recognized in the United States with the protections of the convention. A couple other countries have done similar things, but for the most part, the convention applies to so-called foreign arbitral awards. And then finally, the reciprocity reservation, which Arya briefly referred to. Contracting parties to the convention have the right under Article 1 to apply the convention only to awards that are made in countries that will, in return, reciprocally recognize awards of the state that's asked to recognize a particular award. And therefore, if a country, for example, is not a party to the New York Convention, go back to my Taiwan example, then countries that have adopted the reciprocity reservation would not be obligated by the convention, even though a Taiwanese award would be a foreign award, would not be obligated by the convention to recognize those awards because of the reciprocity reservation. Let's move to the next slide and actually move through all these slides very quickly until we get to D. And for those of you in class, you will have the slides and you can see what I have only very, very briefly summarized for you because I'm anxious to go. Let's go back. Perfect. Arya touched on this very briefly, but it is actually, although it sounds boring, of considerable importance. Once you have your award, as a practical matter, then what do you do to try and get recognition of the award? Under the New York Convention, the issue of how you prove the existence of the award in a national court is specifically addressed. It's specifically addressed in Article 4 in particular. It's also addressed by many national arbitration statutes that implement the convention. The basic purpose of both the convention, Article 4 of the convention, but also national arbitration law, is to simplify the process of proving the existence of the award and thereby to facilitate the speedy and cheap, inexpensive, expeditious enforcement of awards. The basic idea is to reduce the possibility of technical or formalistic barriers to recognition and enforcement. And so let's look at the next slide. Article 4 in particular of the convention requires, and we can move to the next slide to see this in a little more detail, what Article 4 provides. To obtain recognition and enforcement, the party applying for that recognition and enforcement shall, at time of application, supply the duly authenticated original award or a duly certified copy thereof, B, the original agreement referred to in Article 2, that's Article 2 of the convention, and it is referring to the arbitration agreement, because that's what Article 2 addresses. And then finally, if the award, and Arya mentioned this, isn't made in the official language of the recognition forum, a translation of the documents, which is certified by somebody. So what does all that translate into? It means you need a copy of the award with an appropriate certification. It means you need a copy of the arbitration agreement with the appropriate certification, and it means a translation if it's in a different language, again, with some sort of official stuff attached to it. In practice, and we don't need to go through the following slides, in practice, national courts have approached these in a very pragmatic and common sense way. They haven't been particularly demanding with respect to, for example, an incomplete translation. Suppose the awards, as arbitral awards sometimes are, is 300 or 400 pages. Do you really need to translate the whole thing? Suppose that the party's underlying contract is 1,000 pages long. It's a construction contract with multiple annexes. Do you have to put in the entire contract and translate the entire contract in order to present the arbitration agreement, which would be one paragraph or sentence long provision in that contract? National courts have been quite forgiving where parties fail to satisfy these formal proof requirements. Next slide, please. And just very quickly as background to this, the basic point of Article 4 of the convention is to impose a ceiling on national law proof requirements. It is to prevent countries from denying recognition on the basis that the award creditor failed to attach red wax seals to the translations of the award, or alternatively failed to get the certification of the appropriate diplomatic authorities in the arbitral seat. Essentially an effort on the part of the drafters of the convention to make it easy, in accordance with uniform international requirements, to prove that an award actually exists. Under the convention, under Article 4, it's the award creditor that has the burden of proof under Article 4. The award creditor has to prove that there is an award, an arbitral award, that meets the requirements of Article 4, the three requirements I mentioned previously: copy of the award, copy of the arbitration agreement, and translations where necessary. Once the award creditor provides those three things, three pieces of paper, it has satisfied its burden of establishing the existence of an arbitral award. Next slide, please. And there are a bunch of cases that you can look at in your own time that basically say that. And if we could just slide through those, move through those slides fairly quickly, we can keep going. All of these decisions have underscored the fact that the convention was meant to facilitate the proof of arbitral agreements. National arbitration law generally does the same thing. If we go back to the previous slide, oops, one more, please. Advance one, please. One more. There we go. And you can see Article 35 of the model law, as well as national arbitration legislation in other jurisdictions, does the same thing. And if we could just move forward through the proof slides until we get to E, that would be perfect. Now, once the award creditor has proven under Article 4 the existence of an arbitral award, then the award is presumptively valid and enforceable. And the only way that recognition and enforcement of the award can be denied is if you establish, as the award debtor, the existence of one of the 7 grounds for non-recognition under Article 5, which I just described. We could move to the next slide, please. Importantly, the burden of proof is on the award debtor in these circumstances. The burden of proving the existence of the award is, as I said a few moments ago, on the award creditor, and Article 4's language makes that clear. Once that relatively low burden is satisfied, though, Article 5 requires that the award debtor bear and satisfy the burden of proving that one of the exceptions under Article 5.1 or 5.2 is applicable. As I mentioned previously, in the vast majority of cases, 85, 90+ % of all cases, you don't need to do all this stuff. The award creditor doesn't need to prove the existence of an award. It is voluntarily complied with. But once the award debtor debtor refuses to comply with an award, then an award creditor must seek recognition in the vast majority of all cases, the award creditor satisfies the Article 4 requirements for proving the existence of an award. I would guess that where one has to do that, upwards of 95–99% of all cases involve successful proof of the existence of the arbitral award. And then the real action, so to speak, involves application of Article 5 of the New York Convention and its equivalent provisions in national arbitration legislation. Let's move to the next slide and try really quickly to address. Oops, no, not that quickly, please. Let's go back. There we go, stop. That's good. So, actually move back one slide, please. Back one more. There we go. Oops. Okay, perfect. Stay there. Don't move. Article 3 of the Convention establishes the basic obligation on contracting states, countries that have ratified the New York Convention, to recognize awards. Each contracting state shall recognize arbitral awards as binding. And then you can see in the next sentence, you can't impose conditions or fees that are in excess of those imposed on the recognition and or enforcement of domestic arbitral awards. So basically, a presumption that arbitral awards, once they've been proven under Article 4, will be recognized as binding. This Article 3 needs to be read together with Article 5, which is the next slide, please. And Article 5 begins recognition and enforcement of the award may be refused only if the party resisting recognition, the award debtor, furnishes to the competent authority where recognition and enforcement is sought proof that one of the 7 exceptions that we've described is satisfied. A couple points that are important about this introductory language in Article 5. First, the list of 7 grounds, exceptions for the obligation to recognize is exclusive and exhaustive. And we get that from the language that we're looking at on the slide. And in particular, recognition and enforcement of the award may be refused only if the award debtor provides proof of one of the grounds that is then listed. The only underscores the exclusive and exhaustive character of these exceptions. What this means is a country cannot say, well, the New York Convention grounds aren't applicable, but we in our national law, national arbitration legislation have 2 or 3 other grounds. In particular, we can review the substantive correctness of the arbitral award. And because the arbitral tribunal got this decision wrong, we're not going to recognize the award. That is exactly what the New York Convention does not permit. Article 3 requires recognition of awards once they've been proven under Article 4. And Article 5 of the Convention limits the exceptions to the obligation to recognize to those which are then specified in Articles 5.1 and 5.2. That's point 1. Second point, burden of proof, as we mentioned, is on the party resisting recognition. It must furnish to the competent authority where recognition and enforcement is sought proof that one of the exceptions applies. So putting the burden of proof very squarely on the award debtor. And the final point, Article 5 only permits non-recognition, doesn't require it. And how do we know that? We know that from the language in the preface to Article 5. Again, recognition and enforcement of the award may be refused, not shall be refused or must be refused. Article 5 permits but never requires non-recognition. Next slide, please. And then to look at, I think, more in your own time is this slide and the next several slides, and all the slides will be available to anybody that wants them. The various grounds for non-recognition, and the following slides elaborate on all these various points. What I think I would like to do, in light of the limited time that we have, is to address the questions that Arya very briefly outlined for us, and then we can jointly take questions. And she basically identified two main issues. One being the Nepalese Supreme Court's judgment with respect to the non-recognition of the Korean arbitral award on the basis of either Article 5.1d or alternatively Nepalese public policy. And I'll address that with some reference to a case called Noble Resources versus Xingqing, a Shanghai appellate court judgment from China, and a decision by the Singapore Court of Appeal in a case called Sanam Investments. And then second, I'll spend just very briefly some time talking about Article 5.1e and the non-recognition or recognition of arbitral awards that have been annulled or set aside in the arbitral seat. Let's start just very briefly with the Korean award. And then it sounds to me from Arya's description of the Nepalese court's decision that it got the analytical framework largely correct, and indeed did so in a rather sophisticated way, and also that depending a little bit on the circumstances of the case, which I don't think either Arya or I would necessarily know, might well have come to the right conclusion, the correct conclusion in that case. So just to recap, where we are is with an award made in Korea by an arbitral tribunal against a Nepalese party that is then brought to Kathmandu, to Nepal, for recognition and enforcement. The Korean award is pretty clearly something that satisfies all those jurisdictional requirements that we very briefly looked at a few moments ago. Sounds like it was an arbitral award. It was made pursuant to an arbitration agreement. Now, it doesn't sound like a particularly good arbitration agreement, but nonetheless, an agreement to arbitrate. It was by an arbitral tribunal. It was resolving a dispute. It was final and binding in Korea. Rose out of a commercial relationship and a fine legal relationship. There was some sort of construction contract we heard. Then it was definitely in Nepal a foreign award because it was made in Korea. As a consequence, one of the 7 exceptions under Article 5 needed to be established by the Nepalese award debtor, and the Nepalese Supreme Court seems to have gotten that entire analysis correct, and it focused, I think, properly on Article 5.1d as a potential vulnerability. The arbitral award in this case, this Korean case, is somewhat unusual in the following sense. The arbitration agreement in that case was imperfect in some fairly significant respects. It's imperfect because it didn't either specify an arbitral seat or an arbitral institution or identify any arbitrators. It was, if you want to put it this way, just a naked or bare agreement to arbitrate, which in many domestic contexts may not be a problem, because if you have 2 domestic parties, you know you're going to be arbitrating in their domestic jurisdiction. In an international context, it is a good deal more problematic. It's more problematic because if there's no arbitrators identified and no arbitral institution selected, then unless the parties are able, after a dispute arises, to agree upon the arbitrators, which in this case there's no indication they were, how do you choose the arbitral tribunal, and how do you choose the arbitral seat? Because it's a so-called bare arbitration agreement, you have no, you don't necessarily have a mechanism for doing that. In some countries, those kinds of arbitration agreements are invalid because of a lack of certainty. In many other countries, they are valid, but they still create significant issues. And in particular, they create issues as to how is it that you conduct the arbitration if you don't know where the seat is, and therefore you don't know what arbitration legislation applies to implementation of the arbitration agreement. In this case, the award made by a Korean Commercial Arbitration Board, KCAB, which is the sort of Korean International Arbitration Institution, is potentially quite vulnerable under the convention on the following basis. The parties are only obligated to arbitrate under an institution's arbitration rules if they agreed to do that. Institutional arbitration rules, whether the KCAB or SIC or any other arbitral institution, only applies where the parties' arbitration agreement selects that institution's rules, incorporates them into the arbitration agreement, makes them binding as a contractual matter. And in our case, by hypothesis, we don't have that. We have a naked arbitration agreement. And nonetheless, the arbitration was initiated under and conducted by the KCAB and under its rules. It's a little surprising, to be honest, that the KCAB agreed to administer the arbitration, because most arbitral institutions in those circumstances would decline to do that. Most arbitral institutions would conclude that they lacked prima facie jurisdiction because there's no reference in the arbitration agreement to their rules, and there's therefore no contractual basis for them to do so. And therefore, I think the Nepalese High Court and Supreme Court would not necessarily have been wrong had they said this arbitration wasn't conducted in accordance with the parties' agreement. It was conducted as a KCAB arbitration when the parties never agreed to a KCAB arbitration. Therefore, we deny recognition. That is not a crazy result. That said, I actually think one could be a little bit more nuanced or sophisticated in considering Article 5.1d, because Article 5.1d says that you may deny recognition, optional recall, if the arbitration wasn't conducted in accordance with the parties' agreement. What was the parties' agreement here? The parties' agreement was to arbitrate. The parties didn't say we agree to arbitrate, but not under KCAB rules. It was simply an agreement to arbitrate without specifying the mode of arbitration. I therefore think there would have been a quite serious response under Article 5.1d to the award debtors' argument about we never agreed to KCAB arbitration, along the lines of, well, you also never excluded it. And by just leaving things open, a bare, naked arbitration agreement, you accepted the possibility of a KCAB, or for that matter, an SIC or an ICC or some other arbitral institution, stepping in to fill the gap in your agreement. And it would have been open to you, Nepalese party, to have initiated an arbitration somewhere else, or to have insisted upon an ad hoc arbitration. I think, therefore, one ought to look quite closely at what the Nepalese party did, if anything, in the KCAB proceedings. I think if the Nepalese party defaulted entirely in the KCAB proceedings, there'd be a quite substantial argument that Article 5.1d should not apply, that the Nepalese party had accepted the possibility of some sort of gap-filling measure, either by the KCAB or another arbitral institution, or by a national court in a jurisdiction selected by the award creditor. And if it wanted to object, the time to do so would have been then, at the commencement of the arbitration. If the Nepalese party didn't do anything, I think in the arbitration itself, I think the better view would be Article 5.1d should not apply. I'm unimpressed by the Nepalese court's reliance on public policy as a basis to deny recognition. The fact that the arbitral institution was KCAB in Korea when the counterparty was Korean, I think it's a stretch to turn that into public policy as something necessarily biased against a non-Korean party. Lots of arbitral institutions administer arbitrations involving both local and foreign parties, and I think you would need specific proof that what the KCAB did in this case was in fact evidence of a lack of impartiality and independence on the part of the institution, and I think that would be unlikely. So I promise to be relatively short on both that and the next issue that I will address. And the next issue is Article 5.1e and recognition of awards that are annulled in the arbitral seat. Article 5.1e provides as one of the 5 optional grounds for non-recognition that an award may be denied recognition if it's not final and binding in the arbitral seat, or alternatively if it has been set aside in the arbitral seat. And frequently award debtors in the 10% or so of cases when they don't voluntarily comply may, in addition to resisting recognition, affirmatively seek to set aside or annul the arbitral award in the arbitral seat. And that is sort of the hypothesis that takes us to Article 5.1e. Note that the only place that annulment or set aside can be sought is indeed in the arbitral seat. So in our Korean Nepal example, the only place that the Nepalese party could have sought to annul or set aside the Korean award would be in Korea. It couldn't go to, I don't know, Indonesia or the United States to seek to annul or set aside the arbitral award, only in the arbitral seat. And to continue with our hypothesis a little bit, let's suppose that that's what the Korean party did, went to the Korean courts and sought to set aside the award. And suppose they were successful. The Korean courts set the award aside on some basis. But nonetheless, the Korean party brought the award to Nepal. Could a Nepalese court, properly under the convention, recognize the award, notwithstanding the fact that it had been annulled, set aside in the arbitral seat? And the answer to that is plainly yes, whatever the Germans or other people might think. The reason the answer to that is plainly yes is what we've already looked at in Article 5.1a's chapeau, and it's the same, the introductory text is the same in Article 5.2. The 5 exceptions are grounds pursuant to which an award may be recognized, may be denied recognition, not shall. And that is really underscored, I'm not sure which slide this is on, by Article 7 of the New York Convention. Article 7 of the New York Convention, which is quite important to its overall structure, underscores that non-recognition is permissive, it's optional, it's not required, it's not mandatory. What Article 7 says, and I don't know if Abba or others can find it, but what Article 7 says is that the convention shall not deprive any party of the treatment accorded to an award under national law that is more favorable than that of the convention. And the specific purpose of Article 7 was so that if an award would be recognized under national law, even if it could be denied recognition under the New York Convention, nothing in the convention took away your rights to recognize more favorably under national law. And in particular, it was aimed at things like the then existing French arbitration legislation, which did not permit non-recognition based upon annulment in the arbitral seat. Unlike the straw model law, which basically tracks the New York Convention, Article 5 is basically verbatim reproduced in Article 36 of the model law. The French arbitration legislation both did and still does omit as a ground for non-recognition the fact that an award was annulled or set aside in the arbitral seat. And Article 7 was meant to make sure that that kind of more favorable grounds or bases for recognition of foreign awards under national law wouldn't be taken away or compromised by the New York Convention. So circling back to what Nepal could do, and that's the important bit, what Nepal could do under the convention, if Nepal wanted to recognize the award, notwithstanding it having been annulled in the arbitral seat Korea, Nepal would not violate the convention by doing so. A different question is, should Nepal do that in particular circumstances? And the circumstances in which Nepal should do that might be fairly limited, and one could talk about that. But almost all countries have recognized that in some circumstances, not only can they recognize an award that was annulled in the arbitral seat, but they should do so. Classic case was Kromaloy, which Arya mentioned, but I'll talk about both it and the Yukos case in Russia, just very briefly. Kromaloy case, a non-Egyptian party arbitrated, seated in Cairo, against an Egyptian state entity. Arbitral tribunal made a unanimous award against the Egyptian state entity in favor of the foreign party, $100 million or so. The first instance court in Egypt did an annulment action brought by the Egyptian party, denied annulment. But in Egypt's highest court, 3 guesses what happened when the Egyptian state entity sought to annul or set aside the award. The Egyptian court looked in some detail at the substance, the merits of the arbitral tribunal's decision and concluded it disagreed. It thought it reached the wrong result, and that therefore, since the arbitral tribunal was wrong, it was going to annul or set aside the award. That award, the so-called Kromaloy award, was nonetheless taken, notwithstanding its annulment, in Egypt, the arbitral seat, to various other places, including France and the United States, for recognition. Both France and the United States recognized the award, notwithstanding the Egyptian annulment. The French said, well, don't bother me with stuff about annulment in the arbitral seat. It's not part of French law. Goodbye. We're recognizing. The Americans spoke a little bit more, said a little bit more. They said, New York Convention establishes very pro-arbitration, pro-enforcement recognition regime. We will consider the grounds on which the award was annulled, and if they're consistent with the convention's policy, we will deny recognition. But if they're not consistent with the convention's policies, we will recognize, because for all the reasons Professor Bourne said a few moments ago, the convention leaves us free to recognize awards. And they concluded that the Egyptian court's scrutiny of the correctness of the arbitral tribunal's substantive decision was inconsistent with the convention's pro-enforcement regime. They didn't say, but you got to think what was in the back of their mind, that they didn't particularly trust the local courts in deciding these issues in a case involving a local state-owned enterprise. If that's what they were thinking, you sort of could excuse their cynicism and also their willingness to recognize the award. Exactly that same thought process lies, I think, also at the root of multiple national court decisions in the UK, in the Netherlands, in the United States, arising out of the various UCOS cases where some arbitral tribunals seated in the Russian Federation's territory, I mean, the real territory, not the territory they're trying to steal, but the real territory, wouldn't be given effect, and that awards made by tribunals against Russian state entities would be recognized, notwithstanding having been annulled by Russian courts. The courts have in various ways expressed doubt about the independence and impartiality in those circumstances, the circumstances of the UCOS case, about annulments of awards against those state entities. And again, Article 518 of the New York Convention specifically permits this recognition in these circumstances, and in those cases, I think most of us would probably agree recognition was the right, not the wrong thing to do. Anyway, that hopefully addresses all the issues that I was supposed to address, but we're both available now for whatever other questions may arise.
Actually, I have a follow-up, not a question, but sort of a clarification. So the Nepalese party, first, like in the Nepalese Supreme Court case that I discussed earlier, the Nepalese party did not participate in the arbitration, and I think the Supreme Court was like very, very biased towards the Nepalese party. And then it says, well, like the Korean Arbitration Commercial Board should have actually like gone to the courts, like looking at Article 12.2 of the Korean Arbitration Act. If there is no agreement between the parties, and the parties then, like the arbitral institution cannot then single-handedly appoint arbitrators, they should have like gone to court. So the correct procedure in this case should have been to go to the courts and appoint an arbitrator, rather than the Korean Arbitration Board single-handedly appointing all three arbitrators. So,
do we know what the Korean Arbitration Act says with respect to who appoints arbitrators in an ad hoc case? Does it say Korean court? Does some countries where the parties don't agree on the arbitrators and they don't agree to institutional arbitration or some other appointment mechanism, some countries' statutes specify the local arbitral institution as the appointing authority. Is that, I don't think that's the case in Korea, but it's possible it is.
No, so the Korean Arbitration Act does not actually mention the Korean Arbitration Board, and that's why the Nepalese Supreme Court is like, oh well, like
yeah. So I still don't think. I mean, maybe the Nepalese court was biased, maybe it wasn't. I don't think their analysis is necessarily crazy. I do think it is quite odd that the KCAB took the case and was willing to appoint the arbitrators. I nonetheless also think that the Nepalese party's non-participation and non-objection to KCAB doing that is quite problematic, especially given the lack of specificity of the arbitration agreement. I mentioned this a bit ago, but I think where the arbitration agreement simply says we'll arbitrate, and because Korean law is chosen as the substantive law of the underlying contract, it's not crazy to say there's a substantial argument, therefore, that Korean law also applies to the arbitration agreement when there's no separate choice of law clause in the arbitration agreement. And therefore, going to Korea is a reasonable choice, and where a party then, entitled to go to Korea goes to the Korean Commercial Arbitration Board, KCAB, and without objection from the other party, that institution picks the arbitrators. I think you're getting into circumstances where there has been an agreement that requires arbitration, doesn't exclude this possibility, and this possibility is among the more reasonable courses which an arbitration could proceed under, and there's no objection to it. I think there's a pretty substantial argument that you shouldn't deny under Article 551D. I do think it's problem. I do continue. I think it's a really interesting case, actually. I think it's problematic that the arbitration also appears to have been conducted not in compliance with Korean law. Because I do think the Nepalese court, it may well be right that if the Korean Arbitration Act is just plain Unstramon law, Article 12, then what Article 12 says is you're supposed to go to the court in the seat. So even if we're assuming that the seat is Seoul, the seat is Korea, going to KCAB isn't what the statute provides for. And the correct thing to have done would have been to go to the Korean court for appointment of the arbitrators. I mean, so bizarrely, I think that probably would have been even less favorable to the Nepalese party, but that's another story.
Yeah, I mean, to add to that, I think the Nepalese party then says, oh, well, we never received any notice of the appointment of the arbitrators. So they're like, well, like we never received any notification to like object in the first place. And then the other thing was, I think the Korean party then says, oh, well, we tried to submit this thing to the we tried to send notice to your Nepalese office, but it was returned. So that's why we submitted it to your parent company, which is in Korea. So they then like give a notice to the executive director of the parent company. And then the Nepalese court then says, oh, well, like the executive director of the parent company could not actually take notice on behalf of the subsidiary. And yeah, so there was like it's a really interesting case. If it was in English, you could read it, but it's in Nepalese. So yeah, it was a fun case. So actually, like as a follow-up to the Article 51E point, so actually I have like threefold follow-up. So first, I think, so there are like various translations of the New York Convention. And if I remembered well, like back in 2018 when I was a student, I remember my professor telling me, oh, well, but the French translation of this says that like rather than the may version, which is like permissive in nature, the French version says shall. And
so the French version does not say shall. Jan Paulson, because he didn't have anything better to do with his life, wrote a law review article on what the 5 different official languages of the convention meant when they said may or whatever it is they said. He looked at the Chinese, the English, the Spanish, the French, and I think it's the Russian, and did a fairly protracted linguistic analysis of each, and concluded that some were equivocal, and I think the French one fits in the equivocal.
Okay, I mean, I'll give you that point. You win.
Yeah, I don't know whether Paulson. My French is confined to wine and cheese and restaurants, so I can't say.
You win, I lose. Okay, so the next question is like, I mean, look, the thing is, I'm kind of like equating this with anti-suit injunction, right? Like, so English courts like very, very frequently say, Okay, like they give like orders of anti-suit injunctions, and then subsequently courts in foreign jurisdictions are kind of forced to follow that, right? So it's the same principle of comity. Like, for example, if the law of the seat of the arbitration says that the award should be set aside, why wouldn't you just kind of agree to that decision based on principles of comity?
That's a fair concern. And I think in the US court, actually in Kromaloy, we sort of identified that and had a lengthy discussion about it. I think the argument is as follows. Where you have an annulment, where you have an arbitral award made in one place and an annulment in that same place, the arbitral seat, you then have two things that you have to pay respect to. You have the award, where the convention applies to the award. Some people, Albert Jan van den Berg, has said that the convention doesn't apply to awards that are annulled in the arbitral seat because the award's not there anymore. It doesn't exist anymore.
Yeah.
That has to be, I'm surprised anybody could ever make that argument with a straight face, because how do you say the award's not there when, like, there's a copy of the award that you already proved under Article 4 of the New York Convention, and where Article 5.1e of the Convention specifically addresses the issue of what you do in circumstances where an award has been annulled in the arbitral seat. It doesn't say there's no award there anymore. It addresses, in the context of things where you may deny recognition, what you do with the annulled award. So the idea that the award just isn't there, it is frankly absurd. Virtually no national court and most commentators haven't taken that argument seriously. So what you have then is you have an award and you have a decision by a national court annulling that award. And they go in opposite directions. You have an award that says A, and you have an annulment decision that says not A. And you got to choose which one of those should you give effect to. Mm-hmm. There's no treaty in the Kromaloy case with Egypt or in the Yukos case with Russia that says give effect to annulment decisions. Instead, there's a treaty, the New York Convention, that says give effect to arbitral awards. And so what the Kromaloy court said is we might extend comity, which isn't like a treaty obligation, it's sort of a soft, fuzzy, we'll be courteous to our neighbors obligation. We'll
raised my eyebrow to that.
But that's all there is. There's no international obligation to recognize a foreign judgment. That's why the New York Convention is so special. And there's certainly no international obligation to recognize an annulment decision. And so you have a convention obligation to recognize the award with an exception, and you don't have any affirmative international obligation to give effect to the annulment decision. And so what both Kromaloy, but also most other national courts, English courts, other courts have done is look at the legitimacy of the annulment decision. Mm-hmm. And in the Kromaloy case, as I mentioned, sort of raising my eyebrow, in the Kromaloy case, I think there was a suspicion that the annulment proceeding in favor of this local state-owned company wasn't as independent as one would want. And why give comity to that kind of decision where you had a unanimous arbitral tribunal that was independent and impartial that reached the opposite result? And I think taking a big step backwards and trying to look at this more globally, the purpose of international arbitration is to provide for independent, impartial, objective resolution of commercial disputes. It's exactly to get away from politically non-independent local courts favoring local parties and provide for independent dispute resolution. In those circumstances, I come out fairly strongly on the Kromaloy side of the scales.
Yeah, I mean, I think you missed this out, but like I think the Chromalloy judgment also kind of discusses Article 7 of the New York Convention. Um, I mean, yeah, maybe you would want to kind of discuss that as well.
Yeah, but Article 7, I tried to mention this before, but Article 7 pretty clearly, um, Article 7 pretty clearly preserves the right to recognize awards that have been annulled in the arbitral seat. I think that's the main thing it was directed at. Article 7 goes out of its way to say nothing in the convention takes away a right you may have in a country to have an award recognized. So,
yeah. Okay, I think I'm done grilling you.
doubt that.
Okay, maybe somebody from the audience, like if you have any questions for Gary. I know all of you are here for Gary, so if you have questions for him.
Yeah, hi, Gary. And then hi, Arya. I've got
Hi.
a question for both of you. So I know both of you are very busy people, but I don't know how you guys manage all of the cases that you do, along with especially Mr. Bond, who writes various publications, basically an encyclopedia of international arbitration, and especially Ms. Ara Dixit, who works and still manages to come to this session and manages to coach few teams in mooting as well. This is a question for both of you. How do you manage?
Okay, Gary, why don't you go first?
I think I'm not sure what Arya's answer is. I think for me, but perhaps for others as well, you really have to like what you do. If you don't like what you're doing, if it doesn't really excite you, then maybe you shouldn't be doing it. Maybe you should be doing something else that you really do like. If you don't like what you do, you're probably not going to be that good at it because you won't throw yourself into it entirely. I think the way that but I suspect other people also both manage to, but also choose to devote so much time to professional or similar kinds of things is because it brings its own enjoyment and fulfillment. Find something in the law. Maybe it's arbitration, but maybe it's tax or antitrust litigation or like whatever. But find some aspect of professional life that you actually enjoy, that you like, because you're going to spend a lot of your time doing it. And if you don't like it, it's a waste of your life. And you'll be the best that you can be if it's something you do actually like.
That's a good answer. I don't know. I think I just wing it, like just take it one day at a time. I think I just like kind of enjoy like telling people you're wrong, you're very, very wrong. Like, so I think that comes with, I mean, that's one aspect of litigation. So yeah, I think it's just about exactly like Gary said, like it's about enjoying what you do. And I mean, I think if the other team that I'm coaching for their FDI moot is like also here in this call, yeah, I really enjoy like just kind of spending time with people and sort of helping them. So I think that's one aspect, like me trying to like help and kind of be involved in whatever I can, in whatever way I can with my country. So that's one aspect. So that's why I also like doing these classes with you and also kind of learn the Nepalese aspect. The other is just, I think, yeah, like loving what you do and just being passionate about it and yeah, and having good mentors and bosses who just like encourage you and promote you. And yeah, I mean, but all of you would be like very, very maybe shocked to know that my that I'm like actually taking like a 2 or 3 month break, coming back to Nepal and actually working with the Tibetan refugees and living in like kind of a remote part of Nepal for a month in Giling and Chusang and working with the refugees for a month. And yeah, I mean, thanks to my mother who kind of made this happen for me. And yeah, so I mean, after June, I'm actually gonna be in Nepal for most of it, maybe a good month or 2 months. So yeah.
If anyone else in the audience has questions for either Gary or Arya, please unmute yourself and just fire questions.
Or you can do by there's one in the chat.
Okay. Maybe do you want to read it, Prajwal?
I'll read it for you. Does party autonomy in the terms of contract and in particular arbitration agreement be limited to the applicability of domestic arbitration laws, or will it even extend to the application of model clause while adopting arbitral rules such as UNCITRAL, SIAC, and others? There's ambiguity as to whether these rules are to apply during appointment procedures, or can the omission of specific appointing authority will be considered as an exercise of party autonomy to rely on the national legislation with regards with the appointment part?
Why don't I take a shot at it? It seems like the question's provoked by the Nepalese case, the second one that Arya mentioned, and that we came back to, the 5-1D case. Let me try to sort of work through the question. Does party autonomy in terms of contract, and in particular arbitration agreement, is it limited to the applicability of domestic arbitration laws, or will it extend to application of the model clause? So party autonomy very clearly allows several different things for the parties to do, and their choice when they've done that will be respected. That's what party autonomy means. Party autonomy includes, as the question suggests, selecting a particular national law to govern either your underlying contract or alternatively your arbitration agreement. You could agree, for example, as the Nepalese party did in that case, that Korean law would apply to their underlying contract. They could also agree that it would apply to their arbitration agreement. Party autonomy, though, also extends to other aspects of the underlying contract and also the arbitration agreement. It extends to agreeing on the price, agreeing on terms of delivery, and importantly, in the context of arbitration, it extends to what's the language of the arbitration, what's the arbitral seat, how many arbitrators will there be, and now coming specifically to the question, do we accept an institutional arbitration as opposed to an ad hoc arbitration, and in particular, do we do that by agreeing to the model clause that an arbitral institution like SIC or the KCAB would prescribe? Very clearly, I mean, one of the main ways that parties actually exercise their party autonomy is by agreeing to model arbitration clauses, and those choices are entitled to the same respect as any other arbitration agreement. The question then goes on and says there is ambiguity as to whether these rules are to apply during appointment procedures. And in that, I would say no, there's not ambiguity. They definitely, all these rules include provisions about appointment of arbitrators. That's one of the main reasons that you agree to institutional arbitration rules. You get the benefit of the institution assisting in the appointment process. And then the question says there's ambiguity as to whether these rules are to apply during appointment procedures, or can the omission of specific appointing authorities be considered as an exercise of party autonomy to rely in the national legislation in regards of the appointment. And I think what the question is getting at is, can the parties exercise of their autonomy not to appoint an appointing authority, either by selecting institutional rules or doing something else? You can, for example, have an arbitration agreement that only specifies, like ARIA as the appointing authority. We agree to arbitrate, and in the event we can't agree on the arbitrators, Ms. Digzit will appoint the arbitrators. That's the selection of an appointment authority. You can do that. That's also an exercise of party autonomy. And then if you don't do that, I think what the question is saying is that, in effect, a choice of the national arbitration legislation with its appointment mechanism. And if that's what the question is saying, it's actually sort of it's a very nice point with respect to Article 5.1d, because what you could do is, coming back to the Korean Nepalese case, say that it's a little complicated because the arbitration agreement in that case is so bad. But if you assume that what the parties have done is agree to arbitrate in Korea, and recall that's not actually what the clause says. The clause just says we agree to arbitrate, and you get to Korea by saying the choice of law in the underlying contract somehow gets you to a Korean seat. But if you say the arbitration agreement agrees to arbitrate and to do so with a seat in Korea, then you say, and that is impliedly an agreement on the appointment provisions in the Korean arbitration legislation, and that mechanism wasn't followed. That's a very serious, intelligent way to look at the issue, and it underscores how the Nepalese Supreme Court's refusal to recognize the award, whether or not the sort of the precise way that they explained that was good or not, the outcome isn't crazy at all.
Do we have any more questions? I mean, I already have like so many questions that people have sent, but I'm conscious.
May I ask the question before you come to them?
Yeah, please.
May I ask the question before you
Yes,
proceed?
of course.
Oh, thank you. Professor Born and Arya, can I ask you, can you share maybe one memorable application of public order that comes to your mind? Because as we all know, it can be quite unexpected from case to case. And if you have some in mind, can you please share with us? Thank you.
So a case where public policy or public order is used as a basis to deny recognition?
Yes, maybe in some unexpected way.
Yeah, unexpected. So interestingly, national courts, even though the New York Convention allows them to look to local domestic law and public policy in denying recognition of foreign awards, national courts have been quite sort of reluctant to do that. The overwhelming majority of national court decisions which consider public policy defenses reject them. And they usually reject them also with language to the effect that this exception must be interpreted very narrowly. Sometimes they say we need to look to international public policy, not just our own public policy. It's a little bit in tension with the language of Article 5.2, which says you look to the public policy of the recognition forum. But some courts say, well, when they say the public policy of the recognition forum, what it means in the context of the New York Convention is in fact our understanding of international public policy. And so national courts actually have not very frequently denied recognition on the grounds of public policy. There's an old Chinese case that people frequently cite as a sort of bad example of invoking public policy, where basically the court said, well, we'd have to pay a lot of money to foreigners and that violates Chinese public policy. That is, I think, perhaps not so unexpected, but it's a jarring interpretation of the New York Convention, or application of the New York Convention. You sometimes see there's an Indian case once that denied recognition, where the Indian party said that it lacked the money to participate in a foreign arbitration, and therefore wasn't able to defend itself. The Indian court upheld that argument, and I think in many countries that would be regarded as a bit of a stretch under the New York Convention. Examples that I mentioned briefly already would include where the arbitrators were plainly biased or lacked independence and impartiality. Some countries' courts have after concluding that the arbitrators had failed to disclose quite significant things and were in fact biased and not independent, and that objection had not been waived, have denied recognition on those grounds.
Gary, I'm conscious of the time. I think you have like five more minutes. I mean, this is the most amount of time anybody can get with Gary, unless you're his cats. So would you like me to ask questions about your novel, or would you like me to ask questions about your professional career? I mean, people have sent me like so many questions, but like, I don't know what the audience would be interested in knowing.
Oh yeah.
So I will leave it up to you, or I'll leave it up to Prajwal, like to.
Yeah, I do have a question about the novel though. I know it's a thriller novel. To those who do not know about Gary's novel, it's called The File. Yeah, that's novel. It's a really good book. To those who've not had the opportunity to read it, please read it. Gary, my question for you about the novel is there an adaptation of the novel coming soon on the cinemas?
I hope so, but I'm deeply skeptical that it will ever make it to Hollywood. We've got it. The publisher has organized a script writer, which is what you need to do as the next step in getting it to the cinema. Who's turning the book into a screenplay, and once you have a screenplay, you can then go out and try to find directors, producers, that kind of stuff, actors, actresses, and you put together a pitch pack to try to attract people to invest in a potential movie project. I never believed that the thing would be that the book would actually be published, and I don't believe now that having been published, it will make it into Hollywood, won't make it into the theaters. But I've got my fingers crossed.
But who do you have in mind as the heroine of the movie, like as the actor?
You mean the actress?
Yes.
I don't know. So Scarlett Johansson at one point.
Jennifer Lawrence.
I'm sorry, Jennifer Lawrence is definitely a thought.
Yeah, I mean, I always wondered, right? Like the protagonist of the book is Sarah West, and she's like this 28-year-old girl, and I mean, your personality and character is like quite different from the protagonist. How would you like sort of, how did you imagine that character? How did you like bring her into life? And how did you like see things from like a 28-year-old's perspective? I mean, considering there's substantial age gap between like how old you are now and the protagonist, Sarah West, who's just 28 years old.
I guess whenever you're an author with like human characters, I guess also with non-human characters, right? Like George Orwell's Animal Farm, or if I wrote about my cats. Anytime you're an author, it means you have to put yourself into other people's, not just shoes, but personality. So I think one could ask that question just as easily, not about Sarah West, but about the Russian bad guy. One of the bad guys is an ex-Russian spy, or about another one of the bad people is a Chinese woman. How do I put myself into the shoes of either of them? The age difference might actually not be so important, given that Sarah's a woman and therefore emotionally mature, and I'm a man and therefore by definition emotionally immature. The age gap might work the other way, to be honest. Culturally, trying to cross ethnicities and language and all that is always difficult. On the other hand, we in the arbitration world spend our whole lives dealing with people from different nationalities, and maybe it's not so hard.
Yeah, but like I always wondered, like as lawyers, we kind of write a lot and we write every day. And I mean, and we just like make redrafts of everything, right? But like I kind of think that legal writing is very, very different from writing a novel. And I mean, you've done like legal writing for like most of your life now. And was it like difficult to like switch and kind of like write a novel and kind of bring the characters in like, make them alive and sort of, like it's because legal writing is very like dry and you're like, oh, like the court said this or the tribunal said this, like that's why you're so wrong, right? Like, but the other side is just so beautiful and it's so creative and you're like kind of really like kind of trying to play with someone's emotions, like maybe the reader's emotions, and kind of capture it. But how was it different for you?
No, it's completely different. I mean, you sort of think, right? And I've had other people say this, you sort of think that since you spend all your time writing, it's just another book, but it's like so completely different. When we write as lawyers, it's dry in part because we have all these rules we have to follow. You can't, I mean, some lawyers do it, but you can't really make stuff up. You have the evidence that you're locked into. You have the contract. You have the law. You have to say what the court or the tribunal said, what the statute says, what the contract says. But it's even worse than that in a way, right? Because there's all these procedural order number 1 tells you, this is the page limit for this thing, and this thing is a statement of case, and it shall do this, and it won't do that, and the IBA guidelines or the IBA rules on the taking of evidence tell you got to rely on witness statements, and here's what the witness statements have to look at. It's really sort of regulated and prescribed. And when you write a novel, there's no rules. Even once you have the plot, Jeb and Sarah are in this Italian town, and A, B, and C are going to happen. There's like a billion different ways that A, B, and C could happen. And you sit there with a blank piece of paper in front of you, and it's both unbelievably liberating, and if you can put anything down, and equally sort of frightening and disorienting because you can put anything down and you don't really know how you choose between all the various options.
Yep.
Anyway.
Yeah, I think we're like past the time limit.
That's time, exactly.
I think Gary, like the kids really wanted to have a picture with you last time, so do not like run away.
All right.
Do not run away this time.
How do we do it? Go full screen or whatever?
Yeah, I don't know. Who is taking like a screenshot? I'm not sure.
Ava is taking it first. So if Ava, tell us when you're ready.
If everyone could please turn on your cameras if it's possible. I'll be taking the screenshot in 3, 2, 1. Thank you.
Thank you. Thank you so much, Gary, for taking the time. And thank you so much for your detailed analysis of how the Nepalese Supreme Court could have analyzed the case. I think it made for a very, very relevant discussion for all of the Nepalese students who have joined this call. Thank you so much for taking the time. We're really, really grateful.
Thank you, Arya, and Kathmandu University School of Law, and Bajwal and Kafka for having organized this. It was a lot of fun. Thank you.
Thank
Bye.
you. Bye.
Yeah, for the remaining participants, it is 12, but I have you guys in the session and we'll be bringing more. Yeah, thank you.